One of the storylines of this session was the closely watched impeachment of a Fayette County Circuit Court judge. Last week, the state Supreme Court issued a ruling to halt the impeachment and disclosed that the judge was facing a parallel proceeding by the Judicial Conduct Commission, which led to the Senate on the final day of session indefinitely tabling the trial that would have begun this week. That same day, both the House and Senate approved resolutions censuring Supreme Court Justice Kelly Thompson for his suggestion in the court opinion that lawyers involved in the impeachment could risk losing their law license or even be put in jail, charged with a Class D felony.
Nobody in this body, under the speech and debate clause, which is protected for what we say, or under those provisions of the Constitution for which we are guaranteed our powers, should be threatened by a judge by loss of license or imprisonment.
It is equally as important that our judges be able to interpret the law without fear of reprisal, and that they too have that immunity to be independent and to rule on the law as they see fit.
The censure resolution calls for a complaint to be filed against Thompson with the Judicial Conduct Commission. Representative Burke, I'll start here with you. Legally speaking, I believe y'all are both lawyers here in the room. You know, what kind of weight does this action hold? How does it hit the legal community? I know that a censure can be felt as a little bit more than a slap on the wrist.
Well, I think that the censure not only was inappropriate, but I think it's a shot across the bow at a time when tensions are high. We are barreling toward a constitutional crisis, and I don't think that that's what Kentuckians are wanting or needing. At a time of uncertainty at the federal level, the international level, more uncertainty at home isn't a healthy thing. So while I can understand the anxiety that President Stivers may have been feeling as it related to his profession as an attorney, I do find it confusing and almost disingenuous that the House earlier in session promoted a bill that would have abolished the Kentucky Bar Association, saying that the Supreme Court of Kentucky is the one who should regulate and discipline attorneys. But then we turned around and said a Supreme Court justice shouldn't be talking about disciplining attorneys. So I'm not sure. What is it? What should we do?
Representative Roberts, your thoughts?
Yeah, I just want to be clear that I'm not going to comment on the substance of the impeachment regarding Judge Goodman, but to the point of the censure, we're already in a constitutional crisis, and it was started by the Kentucky Supreme Court. And it was done so because Section 66, Section 68, and Section 109 of the Kentucky Constitution is clear that the legislature has that sole power. That is entirely within our purview. No other states that have language to our effect or at the federal level has stated that impeachment is subject to judicial review entirely. And Justice Thompson's remarks really demonstrates the nature of this constitutional crisis goes even beyond that. His comments were a direct threat to legislators for invoking their legislative authority that is invested in us in our Constitution. That is a deprivation of a republic, which our U.S. Constitution guarantees to all 50 states. There's First Amendment concerns as well in terms of federal courts talking about professional retaliation for free speech. And frankly, since the 1870s, we have had strong criminal penalties for conspiracy against rights. I'm not saying that it's gone to that level, but what we have is a true constitutional crisis. This censure was the legislature stating that we have that fundamental authority, that is within our right to initiate impeachment proceedings, and that any effort against that is not only an assault on the individual attorney legislators, it's an assault on the Constitution itself.
In the Senate debate, it was suggested by Senator Wheeler that the legislature is first among equals. Senator Thomas called that a dangerous statement. We only got a minute left here or so. What do you think about that particular part of the argument, Representative?
Well, I think the Kentucky Supreme Court agrees with that statement, given that they have repeatedly held that the legislature is the policy-making branch of the Commonwealth. We have the right to write the law. They have the right to interpret the law, and of course they have judicial review when our laws violate the Constitution. But that said, who is the entity that's writing the law? That's us. Who is the entity that is the most responsive to the public? That's us. Especially in the House, we can be fired every 2 years. We have only 45,000 bosses, where you take someone with there's 6 districts in the Commonwealth, that's about 750,000 people per. So we are far more responsive to that. So I would actually maintain that even the Kentucky Supreme Court agrees with us.
Last word on this, Representative Burke.
Even if the legislature is the first among the three branches, those branches are equal. And it's often recited in the House that we are no longer equal and that we haven't ever been equal, but I disagree with that. I think that all three branches have a role to play, and even though the Constitution is clear that we do hold the power of impeachment in the House, that doesn't mean that that power is completely unchecked. The Supreme Court of the United States has found in cases like Rose that there are guardrails and limits to the power of impeachment.
All right, and I imagine that there will be a lot more to come on this particular item as we watch it here in the newsroom.